we are learning tonight that yesterday's Blockbuster testimony may have changed the calculus inside the Justice Department about how strong a case they may actually have against the former president. Joining us now is David Rohde. He's the executive editor of TheNewYorker.com. He's got some new reporting on deliberations inside the Justice Department regarding charging Donald Trump. He's also the author, most recently, of In Deep, the FBI, the CIA, and the truth about America's deep state. David, good to see you. Thank you for making time to be with us tonight. Since the attack on the U.S. Capitol, one of the things that's been debated in legal circles, if not doubted outright, is whether or not there's enough evidence for the Justice Department to actually prosecute Donald Trump. Did Cassidy Hutchinson's testimony yesterday change that?
I think it did. And the key thing is his mindset. It's what you outlined, that he knew what he was doing was wrong. It's this issue of, can you show corrupt intent? And there's a very big difference between, as you said, calling on your supporters to fight versus encouraging an armed mob to assault the United States Capitol and then trying to join them and lead them as the president of the United States. So I've talked to multiple former Justice Department officials, and they do think this changes things. And then separately, the feeling inside the Justice Department is that they have been aggressively investigating this case. There are weekly meetings where Attorney General Garland is updated by top officials in the Justice Department about the latest information in the investigation as a whole, the sprawling investigation, but including evidence against Donald Trump. There's no decision yet on whether that there is enough evidence, but Garland is pushing. He signed off on the letter that asked for more for all the transcripts from the January 6th committee. That was a few weeks ago. And as you mentioned, there's been a flurry of searches of subpoenas being issued. Phones were seized of John Eastman and Doug Clark, who was trying to become Trump's if you will, big lie attorney general. So there is movement inside the Justice Department. And again, I'm hearing from former officials this new evidence will change their calculus. But I just want to be frank, no one knows. There's no final decision yet. But this was a big moment yesterday.
Let's talk about the John Eastman phone situation. Why is that important?
It's very unusual to seize a lawyer's phone. You have attorney-client privilege. It's a long-held American right, and that should be respected. So that suggests that there is significant evidence. You have to show a judge that there's probable cause that a crime was committed, and that there's also probable cause that evidence of that crime would be on the phone. So both Eastman's phone and Clark's phone were seized by federal investigators. And that shows, again, judges are saying there's significant evidence here. And it's, again, to the credit of the Justice Department that they're carrying out, they're seizing these phones. And then they've issued subpoenas, I think, in at least 4 states. I know Georgia and Arizona, trying to get records and evidence from some of these fake electors. That's a focus of the investigation as well. This scheme to have Trump electors basically steal multiple states' electoral votes, before January 6th. So again, much more aggressive moves by the Justice Department.
Let's go back to the committee. When we talk to members of the committee, some of them say it's important to outline the guardrails that didn't exist so that they can determine what legislation should exist in the future or how we clarify things. But there are some members of the committee, including the vice chair, Liz Cheney, who have maintained from the outset that Trump and his allies knowingly and intentionally broke the law, and that there are crimes to be had here. The Department of Justice needs to weigh that, because the committee, even if Liz Cheney's right, can't do anything about that. Only the Justice Department can say that there seems to be enough evidence for us to actually charge either Donald Trump or Rudy Giuliani or one of the people in that circle. Where are we on that front?
I think the committee's done a tremendous job at educating the public. One member of the committee told me that their goal was to win this politically, to weaken Donald Trump politically. And I do think there are, Republicans that are convinced, Bill Barr, dismissing this idea that the election was stolen. Another aide, Bill Stepien, saying the same thing. I think there are Republicans who think of Trump running again, and they hear these accounts from Republicans including Cassidy Hutchinson, and there's a fatigue that this person is going to come back who's so erratic. So I think the committee succeeded there, but in the end, it will be the Justice Department. And again, I heard today from a former official who's very much sort of a centrist, and actually a defender of Bill Barr. He felt that the Cassidy Hutchinson evidence brought a criminal charge for obstruction of an official proceeding. Mm-hmm. That would be stopping the Electoral Count Act. That the legal standard is, was there an official proceeding? And the answer is yes, obviously, counting electoral votes. And then again, there's this corrupt intent that was shown by Trump's actions and what he knew. He knew that was an armed crowd. He urged them to storm the Capitol, and he tried to join them. So it is a big moment. And obstruction of an official proceeding is the thing that Liz Cheney's been hanging her hat on. That's the thing she says is the most important charge here. And it's important to note that under the law, in that particular case, the intent is secondary to the actual obstruction of the hearing, if that actually took place. David, thank you very much. Good to see you, as always. David Rohde is the executive editor of TheNewYorker.com. We appreciate you and thank you for your reporting. Thank you.